Paul Bolster and Henry Kelly have done great work as our co-chairs of the Reentry Committee. So with that, I'll turn it over to you guys. I look at the format today being very casual. If you will just present each policy option, the barrier that your committee has identified and the recommendation of the committee, and then we'll just open it up to discussion and debate as the council sees fit.
The first...
What number are you, Paul?
23.
Push the button.
The first item deals with driver's licenses, where driver's license is suspended for convictions, and then it becomes a difficulty on the back end to get the license back. And so the recommendations is that the driver's license suspension for drug offenses whose crime is not related to the operating of a vehicle. In other words, you're convicted of a drug offense, you can keep your driver's license, it's suspended while the criminal process goes forward, and then it's available to you at the end, improving the ability of people to come out with some ability to move around the community, get jobs, get employment once their once their prison period is finished. Any questions about that?
I know both Judge Deal and Judge Boggs have some questions.
It's 25.
25. Okay. Y'all can push the buttons on your thing, it lights up.
Are there any limitations to the lifting the suspension of driver's license? Like, I think it would be appropriate to say, if you are convicted of a drug-related offense and you can certify that you received treatment in prison, that then the suspension would be lifted. Or if you're not in prison but you're on probation or you're sentenced and you receive and successfully participate in drug treatment, then you would be allowed to keep your license. You know, I think that we ought to use this as a way to coerce people to do better in their life. And if you want to do better, we're going to help you do better. If you're not going to do better, we don't want you driving on the roads and putting other folks at risk either. So that would be my only recommendation, would be to say you can get a driver's license, or your driver's license would be suspended so long as you can show either you received treatment in prison or you're receiving treatment in the community as part of your sentence. Then you would be able to maintain your driver's license.
I echo those concerns. For the benefit of the council members that were not on the council last year, you may not be aware, but one of the concerns that was raised to the council during the 2012 term was this concept of the impediment imposed by the failure of some of these offenders to have driver's licenses, and the impediment that it poses in their inability to complete drug treatment programs, specifically accountability court programs. And so last year, we suggested and recommended to the General Assembly, they adopted and have now, as they've been passed and codified, a provision in law that allows for drug court judges to unsuspend a drug court participant's or an accountability court participant's driver's license as a reward for compliant drug court behavior, and likewise gave them the commensurate obligation and duty and responsibility to suspend, while in drug court, the license of a drug court participant as a sanction for behavior that was not in keeping with the standards of the program. The concept, therefore, was one of let's look at what kind of an impediment this driver's license issue is imposing. And I think Judge Deal's comments are very appropriate, in as much as if that same concept holds true now, and the real goal of this is not just simply to abolish a statutory framework that has been in place for quite some time that automatically suspends the driver's license of anyone convicted of a violation of Georgia's Controlled Substances Act, but rather ensure that to the extent these offenders that are being released from prison are going to participate in a program or need a driver's license for work, that they demonstrate good faith and a willingness to complete programmatic initiatives both in their communities or in prison. And so, you know, we've contemplated, and I think we will hear more discussion about a certificate of rehabilitation that a participant might receive, an inmate might receive within the Department of Corrections, that could be used towards job training, and I'm contemplating, Judge, that maybe a certificate of completion of a substance abuse treatment program within the confines of the prison system would be just the type of certificate that would be necessary, because I don't think this council, nor specifically me, wants to have a blanket unsuspension for all of these offenses. And particularly, we don't want to, we do want to suspend people's licenses when the offense is directly related to their drug use. And so we just need to be very careful, I think, in the language that we include that couches it in terms of it is an earned benefit, and it's earned through completion of programs, and not make it so difficult to monitor those programs and determine whether they've completed it and how we resolve whether they've completed it through an adversarial or due process considerations. So my recommendation would be that we adopt a policy that allows for, under certain circumstances articulated by this committee, that offenders that are released from the state prison system who have completed substance abuse or mental health or any drug sort of treatment programs within the confines of the state prison system, or are willing to do so once they're released, that they have the ability to apply for and have their license, which has been heretofore suspended, unsuspended, so that it is not an impediment to them completing job programs and maintaining employment, which is very crucial, we think, to the success of the inmate once released into the community. So that would be my recommendation.
Thanks, Judge. And I assume that that recommendation would be in addition to the condition that the drug offense cannot be related to the operation of a motor vehicle.
I would say, excuse me, that I think that would be appropriate.
Okay, Judge.
I just wanted to make a comment too. Are we asking for those who don't go to prison, but those maybe who are sentenced to probation and a substance abuse treatment, that they have to complete it first, or a phase of completion? Because I know sometimes employment is required for their completion of that, and the vehicle may hinder them from being able to get a job. So if we could consider for those who may not go into rehabilitation in the prison system, but outside in the community, some kind of phase in.
Thank you. Do we want to address second and subsequent offenses as well? I mean, Judge, to what I heard you say was a carrot and stick approach. If you don't have one without the other. But I would think that we would want to go ahead, instead of coming back and doing it later, is dealing with second and subsequent offenses and maybe increase the time of suspension for those. I'm just spitballing this, Judge, but again, keeping with, if you want to stay clean, you want to do right, we want to help you. If you're not going to do that, do we really want them out on the roadway? So that's my comment.
You want to know that one?
Back to what Katie Jo said, I think there's a method for saying if you're compliant with treatment, you would be able to maintain your license. I think it's important for you to have your license so that you can go to treatment. So if someone, for instance, was in a jurisdiction where there wasn't a drug court, but they had a drug offense and they were put on probation, I would say they would be able to maintain their license so long as they were able to show that they were compliant with treatment. And if they were not compliant with treatment, then that would be something that perhaps probation could bring to the attention of the court, or driver's services. So we could develop a mechanism for saying this person's not compliant with treatment, and therefore their license should be suspended. But I think that it's important for them to have it as long as they're doing what they're supposed to, because we want them to be able to go. We want them to have a job and go to treatment and be able to drive to get there, so that they can put themselves in a better station in life.
Go ahead, Judge.
Okay. Sheriff, getting to the question that you asked, looking at the statutory framework for suspension of licenses for certain drug offenders, and I'm reciting from section 40-5-75, with respect to the first and certainly the second and third convictions, which would result in suspensions, Reinstatement is dependent upon certification that they've already completed a program.
Okay.
That's already in the framework. They can't get a license according to the statutory framework, according to this statute, but without demonstrating proof of completion of a DUI, alcohol, or drug use risk reduction program. Now, we may want to consider that, but I think Judge Deal is correct that while we've already addressed reinstatement for those that are in an accountability court program, there are many who are not, but who are completing a program in their community. And so, obviously, I think, the devil's in the details, and we have to be very cautious about the manner and the breadth of which this statutory framework is going to be recommended. But conceptually, the idea is we want a mechanism by which these offenders returning to the community can get their license back. And I think it obviously ought to be dependent upon their completion of the program that is aimed at reducing their likelihood of recidivism in that respect. There are other levels at which we can address that issue too, which is suspensions for child support payments, for example. That is probably as significant of a problem for some of these returning offenders who have been in prison and as a result not been able to maintain their child support payments, and they've been revoked or suspended for that reason. So they're just concepts that we ought to think about. I think conceptually the idea, it bears more discussion, and maybe we ought to limit our recommendation just to the concept and let the General Assembly determine, based on the statutory framework that's there, what ways would be most appropriate, knowing that that's what our concern is.
Representative Pack?
Thank you, Mr. Chairman. I think Judge Boggs kind of addressed one of the issues. I think I had a question about what crime is not related to the operation of the vehicle. This is a conceptual matter. If you have a trafficking offense, I see when you're transporting, it certainly could get into that. And then the practical matter, I'm just trying to see what the universe of kind of offenders would be caught under, or under that exception, because it's as if you have a possession crime or you have a trafficking crime on Title 16. And if it's trafficking, I could envision that it would always relate to some type of a operation of a vehicle or things like that, other than street corner kind of dealing. Is it the intent to try to, if it's for public safety's sake, isn't that covered by Judge Deal's comment about someone who's completing a drug treatment program, thereby they're no longer be a threat to public safety? So I'm trying to understand why the related to the operation of vehicle language was in the policy.
Very good question. Thank you, Mr. Representative. Reading from the statute, the offenses which trigger the automatic suspension include but are not limited to possession, distribution, manufacturing, cultivation, sale, transfer, trafficking in, attempt, or conspiracy to possess, distribute, manufacture, cultivate, sell, transport, or traffic in a controlled substance or marijuana. I think the bulk of the suspensions that I saw as a trial judge, I hope Judge Deal would agree with me, the ones that you're really after that I would presume are unrelated necessarily are the simple possession charges. The VGCSA possession of marijuana less than an ounce, which is a misdemeanor, but nonetheless carries an automatic suspension of a license and may not be related at all to the operation of the motor vehicle. And those are the ones that you're really after. I would concede that you're likely correct that with respect to a trafficking issue or sale, possibly, that those are probably related to the use of the automobile. May even trigger forfeiture issues, but it's the simple possession charges that are the ones that are the most problematic. Out of Judge.
JP? I'm sorry. Judge, do you want to respond?
I'd just say that I think there's lots of folks that get arrested for drugs that are not involved in a vehicle. I mean, trafficking is just possessing 28 grams or more of cocaine or methamphetamine. So I have lots of folks arrested for trafficking at their house. They're not, they're not in their vehicle. And I think some of the difficulties we see with driver's license is you have multiple suspensions that it becomes very complicated where somebody has a suspension, they have to get that suspension dealt with before they deal with the next suspension. This would hopefully help resolve some of those issues to make it much easier for somebody to, if they're doing well, we want to encourage them. If they're not doing well, then we want to keep them off the road.
JP?
Yes, this goes along with what Judge Boggs had just read from the statute as far as the misdemeanor, and then back to Katie Jo and Judge Steele's original statement. As far as individuals that were, say, charged an offense and then received probation, they were incarcerated, but they still carry the automatic forfeiture of license privileges. At that point, that to me, that looks like, a barrier to employment. Immediately by suspending a license, somebody that comes in, has a charge, gets probation, they could go back to work the next day. If they don't have a driver's license at that point, that could take and remove them from employment, which could increase the recidivism rate. So I fully agree with being very cautious with the language. As somebody in the situation that Katie Jo mentioned, they may not, fulfill the requirements for the treatment program, or it may not be accessible to them because of geographic location. I would just hate to see us, limit individuals that were starting out, on a lower level of the offense from increasing if we limit their employment, limit their income, things like that.
Sheriff?
I don't have any numbers to back it up, but to address the representative's question, I would think there's a significantly higher number of people that are arrested for non-driving offenses related to drugs than there are for driving offenses related to drugs. And I just see nods of the head from those of us that see that kind of activity. I would think it would probably trigger more for people not driving than for driving.
Ms. Vandross?
Yes, I can envision, and we've seen some cases where, let's say a parent allows their adult child to come back home, and unbeknownst to the parents, the child is, or the adult is dealing drugs inside their home. A lot of times, everybody in the home is arrested, and I can see parents losing their driver's license for these reasons.
That's a good point. Any further discussion on this recommendation? Sure, Paul.
I appreciate the recommendation. I think we'll go in the right direction. I do want us to continue to look at the broader issues of how identification, licenses, and those kind of things give somebody a chance for a new life. And we've got some more work to do on this, especially on the issue of the ID. When people come out of prison, they ought to come out with an ID. I think we're all intent on doing that. And this is kind of a beginning step here in the criminal sentencing area. But without a license, I mean, you're sort of prevented from participating in the common commerce of the community. And so we have to be very careful about taking that away from people if we want them to rehabilitate in the community.
So the recommendation as written on this preliminary form is eliminate driver's license suspensions for drug offenders whose crime is not related to the operation of the motor vehicle. I am hearing that the will of the council is to expand that language to make sure that it is clear that this is an earned benefit earned through completion of the required programming, and develop a mechanism for those on probation who may not be going to prison, and making sure that's clear on the face of the recommendation. With those additions to this recommendation, do I have a motion to adopt or to reject? Is that all in favor?
Aye.
Opposed?